11 of the 2023 Bogota SIEL conference, and this panel is devoted to supply chains and due diligence. Welcome to the people in the room, and welcome to the people connected online. I am Elisa Baroncini, Professor of International Law at the University of Bologna, and I have the privilege and honor to moderate this panel, which considers other central aspects of the significant changes and shifts of paradigms currently characterizing the governance of the global economy. An economy more and more combined with sustainability issues, which are now inextricably part of the interpretation of the already existing international rules and in the definition of the new discipline for international trade, investments, and finance. It already emerged in the previous sessions of this conference, so brilliantly set up by the SIEL scientific organizers, to whom we all express our gratitude, and we express our gratitude also to Universidad Externado de Colombia and to Professor Alvarez for welcoming us in his so beautiful university. So it has already emerged that international economic law is increasingly characterized by the intervention of the state. In fact, the current international context is characterized by a significant transformation of the relationship between politics and economics. We are experiencing the very end of the period which started in 1989, where it emerged the reliance on the power of self-organization of the market if the market was left free. The reliance on the capability of market integration to bring equilibrium, fairness, and liberal democracy, a confidence which did not prove to be always true. Indeed, in the last 15 years, from 2007-2008, there has been a rethinking of the relationship between politics and economics, starting in particular from the financial crisis and the recession, the migration crisis, the pandemics, the Russia-Ukrainian conflict, the climate crisis, to name but a few of the challenges characterizing international relations and, at the very end of the day, our lives. All the crises I listed just as example provoked an escalation of significant public intervention, of interventions of the states to protect financial markets and the social and welfare structure of national communities, to protect the borders, immigration, to protect the health, to guarantee the military defense, to protect the security and the sustainability of supply chains, the supply of essential raw materials, starting from the supply of energy commodities, and we are experiencing the state intervention to protect the environment, thus also the promotion of green transition to face the climate crisis. In this panel, the selected experts will consider some of the legal tools developed by major political and economic actors in the international scenario to face the recalled main sustainability challenges with reference to supply chains and due diligence, also paying attention to the significant impact that the new trade policies and rules have on private economic operators and analyzing their compatibility with WTO rules. The rules of the House are the following. Around 12 minutes are devoted for the presentation by a single author, and 15 minutes to the co-authored papers are reserved to co-authored papers. Subsequent to the speeches, we will have a debate, taking questions and comments from the people here in presence and the participants online. So we start with the first paper, and the first paper is devoted to CHIPS Act and semiconductor supply chain disruptions, assessing the preparedness and of the multilateral trading system. And it has been co-authored by Manya, Gupta, and Arnav Sharma. They both work at the Center for Trade and Investment Law, established by the Department of Commerce of the Indian government, where Manya Gupta is a senior research fellow, advising the Indian government in trade-related policy making, bilateral, multilateral negotiations, and trade disputes. And Arnav Sharma is a research fellow at the same center, where after an LLM in international laws from the Faculty of Legal Studies of South Asian University, he researches on state-owned enterprises, subsidies, and competition policy, energy, and raw materials. Dear Manya and Arnav, the floor is yours.
Very good morning to respected panelists and here. I hope I'm audible. So we've divided the presentation in three parts. The microphone. Close the microphone, please.
We have the slide.
the-
So we've divided the presentation in three parts. First part covers the CHIPS Act, its provisions, and the nature of semiconductor supply chains. The second part covers is WTO consistency. And the third part covers a way forward. So semiconductors are a ubiquitous element of modern life. They serve multiple uses across various sectors. Modern semiconductors can be classified across various lines, such as their functions, the technology they use, manufacturing processes involved in their making, as well as their processing capabilities. Yeah, that's perfect. For the sake of brevity, the processes involved in the making of semiconductors have been divided into three parts, namely design, fabrication, and assembly, testing, marking, and packaging. Now, each component, however, contains multiple subcomponents which allude to their own specific inputs. Semiconductor supply chains are highly complex and specialized. They rely on multiple inputs across sectors. And some studies claim that a basic integrated circuit chip from start to finish crosses at least 70 international borders. Now, this also implies that supply chain constraints have the potential to exert devastating cascading effects on downstream users. According to some studies, instances of 10-day disruptions at one end of the supply chain can lead to a year-long disruption downstream, something which the world witnessed during COVID-19. Now, moving on to the CHIPS Act. Next slide, please. The CHIPS Act, it amends a previous US legislation called the William M. Thornberry National Defense Authorization Act 2021. The semiconductor-related provisions allocate $52.7 billion to onshore domestic manufacturing capability, research and development, nurturing trained workforce in semiconductors industry. It also focuses on maintaining a reliable supply of inputs used in manufacturing semiconductors through a US-led supply chain, often implying friendshoring and ally shoring of inputs. Now, the Act is also directed at maintaining US edge in important technologies such as microchips. The CHIPS Act provides financial incentives in the form of direct. Can we have the next slide? Yeah. So the CHIPS Act, it provides financial incentives such as direct loans, grants, loan guarantees, and tax credits to covered entities that wish to operate across various aspects of semiconductor production and design, research and development in the United States. Now, in the act of awarding grants, it restricts recipients of grants from engaging with foreign countries of concern, which includes China, Russia, North Korea, and Iran, or any other state as determined by the US authorities. Now, financial incentives under the Act are based on an application process, which is subject to the review of US Secretary of Commerce. Now, when it comes to this aspect, various factors are relevant. An applicant must provide information on operations that it undertakes and its intended consumers. Applicants must demonstrate that they have an executable plan which addresses and mitigates supply chain risks and combats cloning, counterfeiting, and relabeling of semiconductors across different stages. In addition to this, they also need to demonstrate that they are investing in local communities, disadvantaged groups, and collaborating with regional training and educational institutions for STEM workforce training. In review, the US Secretary of Commerce considers various factors, such as the eligibility of a covered entity and its linkage with a foreign country of concern, the type of semiconductor technology that the covered entity intends to produce, and how that technology advances economic, national security, and other interests of the United States. In addition to this, it also covers responsiveness of the covered entity to the national security needs or requirements established by the US intelligence community. In addition to these aspects, there's also a prioritization measure in which, in the awarding of financial incentives, priority shall be given to covered entities that manufacture semiconductors across technology nodes such as mature and advanced to address gaps and vulnerabilities in the US domestic supply chain, entities that provide a secure supply of semiconductors necessary for national security, manufacturing, critical infrastructure and technology leadership of the US, as well as essential elements of the US economy. In addition to this, it also needs to support the resiliency of semiconductor supply chains for critical manufacturing industries in the United States. Apart from the prioritization measure, the CHIPS Act also has clawbacks Apart from a general clawback provision which pertains to dates of execution of the projects, there's also an expansion clawback and a technology clawback. Now, the CHIPS Act incentives operate through 10-year agreements with a covered entity. According to those agreements, a covered entity and its affiliates cannot expand pre-existing facilities or construct new facilities in foreign countries of concern. The only exception to this is the operation of legacy semiconductors, which pertain to the domestic markets of those foreign countries. Apart from this, there is a technology clawback, which prohibits joint research and licensing efforts with foreign countries of concern. Now, in terms of the impact and objective of the Act, in addition to revitalizing US domestic industry, the Act navigates through building partnerships that help US diversify and secure its semiconductor supply chains. Further, the Act cannot be seen in isolation. Coupled with the export controls that US has levied, the US has also sought partnership with allies and leading companies across the spectrum to impose restrictions over semiconductor technology and manufacturing equipment, which is an indispensable part of making of semiconductors. Now, using allies as a proxy to enforce export controls and cut off access to technology for a particular state may seem like a tense affair, as it may hamper commercial operations of entities in the industry. It may also invite reprisals from states in question. In this context, China's response to the situation, amongst other things, includes imposing export controls on essential raw materials such as gallium and germanium, which are used in the making of semiconductor wafers. I'll now hand over to my colleague Manya to cover the next part of the presentation.
Thank you, Arnav. I'll start from where Arnav has left and briefly talk about the WTO consistency of the CHIPS Act and the measures covered within it. China has already raised questions about US measures under CHIPS Act, and the questions essentially cover inquiring into whether this act violates some basic elements of the WTO agreements. First is non-discrimination, because the act intends to exclude any supply of product, raw material, or equipment related to semiconductor to foreign entities of concern. It discriminates between the countries to which these foreign entities belong and the other countries. So it can be a potential MFN obligation violation under Article 1 of GATT. Similarly, although there is no explicit local content requirement or any requirement which results in a prohibited subsidy under the SCM agreement, there can be a de facto local content requirement in the sense that the secretary, when evaluating the applications for incentive, has to make sure that the covered entity is contributing to the local supply chains in the US. So that evaluation part of the application can always be, depending on the practice that follows, can always lead to a de facto local content requirement, which will have a very high threshold to be justified before a WTO panel. Now, the third element that China alleges that it violates is quantitative restrictions, that is Article 11 of GATT, and as a result, Article 2.1 of the TRIMS agreement. Because there is a restraint on the exports that these covered entities can do to foreign entities of concern, that is China, which includes products, raw material, software, equipment, etc. That can lead to that can result in a violation of quantitative, a violation of obligation under Article 11, resulting in quantitative restrictions. Now, in the next part, in our paper also, what we try to do is identify the areas of how WTO existing agreements have successfully countered supply chain disruptions, or has furthered as a justification for supply chain disruptions. One very important aspect for this supply chain essentially is the export controls, because most of disruptions that we can see right now are happening through export controls, and this appears to be a very lucrative and a very important measure where results are visible very soon for countries. So in a way, we can say that Article 11 is sufficient to tackle these kind of challenges, but still we can see we can see an increasing number of export control restrictions when it comes to US's export administration regulation, or Japan's restrictions on chemicals, Netherlands restrictions on EUV lithography, etc. Now, there is also an element of friendshoring, which is similar to Qualcomm export controls in the time of Cold War that happened against Soviet Union. China, Netherlands, and US have recently entered into an agreement to ensure that they impose export controls. US, Japan, and Netherlands have entered into an agreement to ensure that they impose export controls against China in tandem. So this reflects an element of friendshoring or ally shoring, and with that, an attempt of reshoring the kind of production processes that US has previously offshored. Then the next important element or instrument that that WTO agreements have is non-discrimination or non-discrimination obligations, including MFN and national treatment. Most of these onshoring requirements or reshoring policies are characterized by local content measure local content requirements. Although in CHIPS Act, like I mentioned, there is no de facto import substitution as such, but there can be a de facto import substitution. Now, the part of the GATT agreements which essentially results in furthering supply chain disruptions, or I'll say that serves as a justification for supply chain restrictions, is the exceptions or derogations under the agreements. Article 20, general and security exceptions, both for that matter. Article 20, because it has a higher threshold, countries don't really use Article 20 for these. And because semiconductors is essentially a dual-use technology good, what countries tend to do, especially US from its replies to China and other objectives of the act that it has given, it is very clear that it intends to use the national security exception as and when the time comes. The use of national security or security exception under Article 21 has led to a domino effect that we discussed yesterday in the panel, in the roundtable discussion also. What we propose in our paper is a way forward of how these supply chain disruptions, and especially in this stage when two countries are face to face against each other, which are both have very important contribution in the supply chain, which is very sophisticated as it is. Our first way forward, or our first solution is entering into a separate agreement for dual-use technology goods, and maybe a separate agreement for semiconductors, which regulates areas like export and import controls, subsidies and their eligibility criteria, and attempts to make a clear separation between the commercial use of these goods and the security use or military use of these goods. Then in the same suggestion, these agreements can also include parties that are specific to a supply chain, with a possibility of open accession to other parties who want to join later. And the most important part of this solution is a different security exception, at least for a specific supply chain. If we attempt to rework the security exception in GATT itself, that will take a lot of time and effort, and that will also result in ruling out the actual usage of that exception as and when it happens, when some country actually really needs to use it for security reasons. How we propose this security exception can be used in these agreements is by making a very clear demarcation between national interest and security interest, and by limiting and with a possibility of scrutiny of the chapeau of Article 21, which talks about essential security interest, and by adding mandatory transparency requirements on implementation, on imposition and implementation, as well as monitoring of the measures that are in place. Our second suggestion is giving way to bilateral and regional agreements, like IPEF Pillar 2, for instance, that is happening right now, because it leads to a better norm setting and opens a possibility of an international agreement in future on supply chain. However, a con of this issue is that because as the status quo is that China and US are not looking face to face on these issues at all, it can lead to a further geopolitical and geo-economic fragmentation. But then again, it leads to some kind of a norm setting, some kind of an example for an international agreement in future. Now I'll give the way to Arnav to discuss new norms.
The other alternative that we have is slightly more pessimistic. I mean, the CHIPS Act and subsequent global developments, they signal a new normal where supply chains that were earlier based on specialization and comparative advantages are replaced by supply chains focused on reducing reliance or even eliminating adversaries from semiconductor supply chains. This also may be supported, as Manya stated, by the proliferation of regional trade agreements, preferential trade agreements, even mega regional agreements that brings allies in close collaboration with each other and also are supported by mutually agreed normative frameworks. But I would still like to argue that navigating these complex supply chains will be an incredibly difficult task. As supply chains such as semiconductor supply chains involve multiple inputs with their own relevant and subsequent supply chains. This implies that strategic interaction and transactional arrangements, even between adversaries, in a limited sense, cannot be ruled out. And I would also like to argue that multilateral forums, such as the WTO, may occupy a central role in facilitating these interactions at a global level, even though in a limited and a weaker sense. With that, thank you.
Thank you so much to Manya and Arnav. And now I have the pleasure to introduce the second paper. So after having illustrated and analyzed the significant piece of state intervention in the strategic sector of semiconductor and introduced the issue of supply chains, we started dealing with the due diligence, combining it with supply chains. And so I have the pleasure to introduce you to the second paper, which is devoted to trade law aspects of supply chain due diligence. We have two authors for this paper. Lorand Bartels, who is professor of international law at the University of Cambridge, where he teaches in trade law, investment law, and public international law. He's also chair of the UK Trade and Agricultural Commission, advising the UK Trade Minister and Parliament on the new UK Free Trade Agreements. And because of his activity in this field, Lorand was appointed MBE, which means a member of the Most Excellent Order of the British Empire, for services to the UK trade policy. And then we have the co-author Tibisay Morgandi, who is assistant professor in international energy law at the School of Law at Queen Mary University of London. And at Queen Mary, she chairs the Climate Emergency Working Group and directs the Trade Lab International Economic Law Clinic. The floor is yours.
Can I perhaps leave it here? I think I'm loud enough and you can hear me. Good morning, everyone, and thank you, Elisa, for this kind introduction, and to all of you for making it to a 9 a.m. panel. Very pleased to be here today. So what Lauren and I, as Elisa was saying, are going to speak about today are the trade law implications of regimes that impose a due diligence requirement on companies. Now, when we talk about due diligence, this concept has become very popular and has come to be associated with another very popular concept, which is ESG, environmental and social and governance. And there is clearly a private law and company law dimension to this. But there is also a trade law dimension to this, which is often overlooked and neglected. And that's what we are going to discuss today. So what we want to do is essentially two things. First, we want to provide a taxonomy of different types of due diligence regimes. And this is what I will cover. And second, we also want to explain and discuss how these regimes affect trade and trade law. And that is what Lauren is going to cover. So let's start from the concept of due diligence. So the concept in international law has now become popular, but is relatively new. And we can trace it back to the John Ruggie's UN Guiding Principles on Business and Human Rights. And why did he use this concept? Essentially, it was a diplomatic trick to overcome the objections that companies, unlike states, are not subject to human rights obligations. So using the concept of due diligence, we talk about not obligations, but responsibility of companies to make sure that their activities worldwide essentially do not cause human rights adverse impacts. And when there is a risk that these impacts may occur, the idea was company should suspend and terminate, if necessary, business relationships with their suppliers. Now, the UN Guiding Principles on Business and Human Rights essentially establish voluntary standards. And companies, embrace them, especially multinationals, for reputational reasons. But due diligence has now come to be embraced by binding legal instruments. And this is what I'm going to cover very briefly. So we have essentially two types of due diligence regulation. The first type is about self-certifying that products are made in a certain way. And I'm going to refer to two examples. The first, and I'm going to focus on the EU because is the regime that we're most familiar with, but we should say that now also many states at the domestic level are developing these due diligence regimes and making part also of company law, essentially. So the first example is the EU Conflict Mineral Regulation 2017, and the second is the EU Deforestation Regulations 2023, which repealed the previous timber regulation. So these two types of due diligence regimes are about self-certification, essentially. So the first, the one related to conflict minerals. So that regulation requires EU importers to adopt certain measures to reduce the risk that armed groups in conflict areas benefit from the trade of 4 products, the 3 Ts, so tin, tantalum, and tungsten, and their ores, and gold, these 4 products. And the measures that the company need to adopt are set out in OECD guidelines, but essentially the companies need to make sure that they know where the minerals come from, where these minerals originate, and if they originate from conflict areas, then they need to make sure that the supplier is not in any way connected with these armed groups, because essentially the sale of this product will finance these armed groups. But also, it's not just about the company adopting measures and making sure that they know where these minerals come from, but it's also about, having an external audit. So the companies are externally audited, and this is to guarantee to some extent that the companies are doing the right thing. And it's about essentially risk assessment and risk management. And when there is a risk that there is an adverse human rights impact, and in this case, that these minerals come from these areas and they might be used to finance these armed groups, the company essentially has to disengage in its business relationship with these suppliers. Now, there is no per se prohibition on the, let's say, gold coming into the EU market, which is interesting, but the companies obviously can be subject to sanctions. Now, the EU deforestation regulation is similar but slightly different in that it does impose a ban on the product coming into being placed on the EU market. And this regulation essentially requires companies and in fact operators, those that place the product on the EU market, require them to issue a due diligence statement which essentially has to show that the product is deforestation free. And how do they do that? They essentially need to include geolocalization coordinates to show that that product, let's say cocoa, does not come from an area where there has been deforestation. Now, if these products are then placed on the market, the operator has either to withdraw the product from the market or donate it to charity or destroy it. So it's a much, in a way, constraining obligation compared to the conflict minerals regulation. Now, very briefly, these two types of regulation involve a set of conformity assessment procedures where the relevant companies essentially self-certify that these procedures have been carried out. And what's interesting is that this regime concern non-product related production methods. So it's not about the use of the product on the market, but it's about the production. And what value are these regulations protecting? They're not protecting, again, the value that the product is safe to be used on the market, but they are protecting, harm abroad. They are protecting the fact that deforestation does not occur in Brazil and that these minerals don't finance these groups. Now, the third example that I'm going to make is a bit of a different due diligence regime, and it's not really about certification. And I'm referring here to the EU Corporate Sustainability Due Diligence Directive that is currently being negotiated, which essentially asks member states to require companies of a certain size to identify and prevent potential adverse human rights and environmental impacts. But this time is not about a product in particular. It's not about a service in particular. It's about all the activities that these companies carry out abroad and all over the world, and not just, the parent company, the subsidiary, but also all the suppliers. And it's a much, much, much broader catch. And it's not really about certification related to a product. It's really about, can you identify, can you prevent, can you mitigate adverse human rights and environmental impacts abroad? And obviously these have huge trade law implications, which is what Lorand is going to briefly cover.
Yeah, so as Tibi was saying, these due diligence regulations, they come from the world, and in fact, Ruggie brought in these ideas by translating corporate governance language. And it's very easy to overlook the trade dimensions, maybe a bit more difficult when it comes to the first two examples, minerals, which are about importers, deforestation, which is about placing on the market, but particularly when it comes to the new corporate sustainability due diligence directive, no one talks about trade, the trade implications of this, and yet they're big. I mean, even if you look at, and this is for EU lawyers, the legal basis on which these regulations are adopted, the conflict minerals regulation is based on Article 207 of the TIR EU, which is the trade provision. So that's fine, that's well understood. The deforestation regulation is based on 192, which is environment, which is also fine because, environment and trade, that's all right. Corporate sustainability due diligence, Article 50, the right of establishment. No reference to trade, no reference to anything international. It looks like it's entire, and 114, which is harmonization of the internal market. It looks like, from an EU point of view, it's an entirely internal corporate governance idea. And if you look at the documents, preparatory materials and so on, they never mention trade, they never mention WTO, they don't even think about it. Does that mean that there's no trade dimension to any of this? Well, of course not, because at the end of the day, with all this language of risk assessment, and at the end of the day, if you can't, mitigate the risks of the bad stuff happening, you've got to disengage. That actually, disengage means a trade restriction, a fairly obvious trade restriction. Now, so long as this was all voluntary, fine, companies can do what they like and so on, and states are not engaged, there's no state responsibility, there's no WTO violation. But as soon as this turns into regulations, that changes. And now we are talking about measures, to use the WTO jargon for conduct, and the question then arises whether there's a WTO problem, and I think the answer is there is. I mean, if you think about what this means for trade, it means that in the case of the first two, you've basically got we're going to import ban for conflict minerals. The regulation targets importers; they're not allowed to import, basically, from conflict zones where X happens and the money ends up with armed group. That's an import ban. That's Article 11 violation. Straightforward. I mean, I don't think there can be much argument about that. With the other two, well, it's not with deforestation. Vivian is going to talk about this. Nominally, it's about deforestation in the EU. I mean, that's of course a bit fake, but nominally fine. So it's Article 3 is the discrimination. Well, I think, in my view, every time a government breaches, there's discrimination. I mean, you can just more or less assume that the rules are so strict. So, I don't even think there's much point going on about that. But yes, obviously there's discrimination in the sense that, there's more deforestation in some countries than others. And when it comes to the corporate due diligence directive, what's interesting about that in trade terms is not only are we talking about placing on the market in the EU, which can't be done anymore, but you're talking about, it covers exports. So you can't export to companies that do the wrong thing. So you've got, an export restriction. But even more interestingly, we're talking about supply chains, which involve many, many countries. So ultimately, if you have product, raw material comes from country X that is then, processed in country Y, then you go to country Z, all before it comes to the EU. What you're talking about is an interference in trade with any of these links. So you could be talking about interference of, in trade between China and Vietnam. It's got nothing to do with the EU at all. I mean, this is radical, right? And of course, this is, I need to stress, this is inevitable. The EU has said you can't do it, you've got to break that link. So it's a trade restriction which is extraterritorial in the most dramatic way possible. But of course, I think violations left, right, and centre, no question. But as with everything in trade, all the violations are trivial. I mean, I don't bother talking about violations half the time. Whenever I talk with government, I don't worry about discrimination. I can't tell my students that, obviously, because I have to teach them this. But honestly, in the real world, I think it's all just a waste of time. You could spend save yourself a lot of time and just focus on the exceptions, because that's basically what governments need to worry about. And question then is, can you justify this? Well, I don't want to sort of bore you too much with Article 20 analyses, and maybe I can just sort of skip over very quickly, points in bullet point form. I think human rights can always fall under Article 20A and equivalent in the TBT agreement. I don't think that's much of an issue. I think deforestation, maybe if it's climate change related, you can argue that it's territorial and therefore okay, although Tibi, who knows much more about the environment and climate than I do, says that that's not right. So we had a little bit of a disagreement on that, which is, we haven't resolved. So, but that's an argument for, climate change. Certainly the EU's argument when it comes to CBAM and so on, which is it's all about the EU. So that's, the territorial link is there. When it comes to other environmental harms, like polluting a river, I'm quite hardline. I think it's up to that country to worry about its own rivers. The EU can't tell Vietnam not to pollute its rivers. I just think there's no, I think, you need a territorial link unless there is an international agreement or some custom. There's never any custom, just in theory, but an international agreement which gives the EU, in this case, a sufficient interest under international law to protect that river. Now, what's interesting about the due diligence regulation is that they actually go to some effort to identify adverse environmental effects in terms of international treaties, which is unusually careful for the EU to do that. And I think that actually works in theory. So they run through a whole list. There's the Stockholm Convention, there's the Basel Convention. It's always these conventions. Now, of course, for that to work, those conventions need to be enforced between the affected country and the EU. And I haven't yet gone through all of this and worked out, but I guarantee pretty much it's not going to be the case for all countries in the world. So it's a good starting point, but it's not going to carry through the entire way. So I think there's a lot of adverse environmental impacts which are part of the due diligence regulation, which would not be covered by Article 20 in my view. And then of course you've got the whole necessity thing, which is, is there necessary discrimination, is the way I understand the chapeau. The rest of it I think is always blah, blah, and bad jurisprudence. And really just, can the discrimination be justified as necessary? And here, my final point, my final 30 seconds is, actually, the odd thing about all of this is that the due diligence concept came from somewhere totally different. As Tibi was saying, it's a bit of a diplomatic trick. It's all about the problem of human rights and so on, not applying to companies. But magically, when it comes to what you need to do for a trade law justification, which at the end of the day is always necessity, unless it's national security, always necessity. It actually works quite well, because the way this risk assessment process works is you're asking companies to do a whole lot of stuff before they terminate contractual relations. They have to, invest, they have to try and fix the problem. There's a whole lot of stuff. And so if necessity is, as I think, simply about, is there a better way of doing it or not? And forget the blah, blah about proportionality. I think you could say, well, actually, these directives are not bad, because they do ask the companies to go through a whole range of processes before terminating the relationship. It's only, the ultima ratio, the last final thing, in order to prevent these adverse effects, where you're supposed to do this according to the Brugge principles. And so actually, at the end of the day, maybe you have a necessity test built in to due diligence and everything is okay. Thanks.
So thank you for pointing out all these problematic aspects of due diligence, and so of the relevance together with the public actors also of the approach of private economic actors. Now I have the pleasure to introduce the third paper, which is about an elephant that our author identified, which is the deforestation regulation of the European Union, and she will assess the bias of this regulation and the compatibility with the WTO system. And Vivian Rocha, our guest, is a prominent international economic law expert of the Brazilian community. After a PhD at the University of São Paulo, she teaches international trade law and law of international relations at the business school in Curitiba. She is a consultant of the Economic Commission for Latin American and Caribbean and head of the branch of the group on international economic law of the Brazilian branch of the International Law Association. Dear Vivian, you have the floor. Thank you very much. I keep you.
Can you? Okay. Okay, good morning, everyone. It's wonderful to be here in this conference as well, as it's a great pleasure to share this panel with so high-profile colleagues here. I'm sure I have too much to learn with you. Well, my topic involves the matter of the moment, which is the EU regulation on deforestation-free supply chains that entered into force last week on June 29. Briefly, the legislation states 3 requirements for a commodity and derived product to be sold in the EU. First, does not come from an open area, the deforested area, after 31st December 2020. Second, it has been produced in accordance with the laws of the country of origin. And third, proof that a due diligence process has been carried out, as our colleagues told us. The regulation also established a benchmark that classifies countries considering the level of risk of deforestation and degradation of exported commodities. And the regulation covers 7 commodities and derived products, such as soy, coffee, beef, leather, cocoa and chocolate, wood and furniture, rubber, and palm oil. Envisaging several points that have been discussed as discrimination at this regulation, I opted in my paper to make a cutout in how the metric of choice of this commodity was. The EU highlights the choice of these commodities that is based on scientific and cost-benefit analysis of their impact on deforestation. And by June 2025, the Commission will also determine whether it is appropriate to amend or extend the list of relevant products, commodities. And although this regulation will not be applied no later than December 30th, 2024, it has been triggering some concerns, particularly those related to the scope of the selected products and the target of tropical forests as the only climate domain to be protected in all official documents published about the measure by the EU, in detriment of other domains threatened, including the European ones. In my research, consulting the main documents considered by the EU in the EU decision about which commodities will be the target of the measure and its justification, I inferred that they are, first, based only on a few sources, repeating those already used in the other impact assessment report. Second, they are based on biased studies towards tropical forest commodities and derived products. No other climate domain is mentioned, as I told you, in the documents, not even European climate domains. And third, there is an omission in the documents used about European commodities consumed by European citizens. And fourth, there's an apparent uncertain scientific evidence based mostly on the secondary sources that put on check the scientific orientation of the scope of the products encompassed by the measure and its environmental protection purpose. Well, I achieved these conclusions investigating the official documents that could, based on scientific research, and are quoted as cornerstones in the regulation as important to scrutinize the state of art of deforestation and its main drivers. The documents analyzed were, the next slide, sorry, the next one. These documents The documents analyzed were first, the FAO Global Forest Resources Assessment 2020 report. Second, the Intergovernmental Panel on Climate Change, the IPCC. Third, the communication of 23rd July 2019 on stepping up EU action to protect and restore the world's forests. Fourth, the impact assessment of this regulation. And fifth, the consultancy report, EU policy on forest products and deforestation. Putting on the table, my main findings in analyzing these documents are, firstly, both FAO report and the IPCC report are focused on deforestation as a whole and its jeopardizing effect in the environment, not on which commodities are responsible for deforestation. However, the reports brought relevant data to observe the environment landscape from all regions. One thing that calls attention is the division of deforestation in climate domains, as here, and then how not all the domains and data are analyzed by the EU, even they are in the studies quoted. For instance, an important data here, according to FAO, deforestation in each climate domain is diminishing, even though the deforestation rate in tropical domain is higher than others. From 2010 to 2015, it was 10.3 hectares a year, and from 2015 to 2020, it fell to 9.3 hectares a year. Deforestation in subtropical domains also fell, but less than the tropical domain. From 2010 to 2015, it was 0.88, and from 2015 to 2020, it was 0.50. Then analyzing another document, the Stepping Up EU Action to Protect and Restore the World's Forests from 2019, one of the first guideline documents that indicate the EU's ambition regarding forest protection, it's possible to observe an emphasis on the tropical forest domain. And I quote, it states that, while in the EU forest cover has increased over recent decades, the rate of deforestation in other regions, namely in tropical areas, continues at alarming levels. Well, at the same time, it's interesting to highlight that the products associated to deforestation and forest degradation are consumed much more in local level than international level, here according to this document. It states that despite EU imports such as palm oil, meat, soy, cocoa, maize, timber, and rubber, including in the form of processed products or services, and looking at deforestation embodied in total final consumption, the EU consumption represents around 10% of the global share. And according to the EU report from 2013 called The Impact of EU Consumption on Deforestation, Comprehensive Analysis of the Impact of the EU Consumption on Deforestation, quoted in this Stepping Up EU Action document, approximately 2/3 of deforestation embodied in crop products stays in the producing country, while 1/3 are traded internationally. For livestock products, for example, considering the conversion of forests into pastures for grazing for ruminant livestock, the highest share of the deforestation lies in South America, but only 10% is exported from the region. For wood products, approximately 75% of embodied deforestation stays within the country of origin, and 25% of embodied deforestation is exported from Southeast Asia, South America, and to a lesser extent, Sub-Saharan Africa. Moreover, the same report highlights, and I quote, globally, the main crops that contributed directly or indirectly to deforestation include soybeans, 19%, maize, 11%, palm oil, 8%, rice, 6%, and sugarcane, 5%. From these sectors, maize, rice, and sugarcane are excluded from the EU regulation at stake, calling attention to why the second, fourth, and fifth crops that most contributed to deforestation according to the ONU are excluded. However, according to the Q&A published by the EU, the choice of which commodities would be the target of the regulation has been taken based on the findings of the impact assessment. The impact assessment, you can change. The impact assessment highlights its own limitations. There is an extensive literature that has attempted to use deforestation, agricultural products, and trade data to estimate the use deforestation footprint, but the research has gaps. Well, just hurrying up here because of the time. The first list of commodities, the statistics used by some of the reviews reporters here in this impact assessment are old. The numbers have substantially changed. Some papers start from a preliminary list of commodities, which makes them incomprehensive, and others focus only on tropical deforestation and tropical products. The first list of commodities quoted here involved these products, and the list of commodities was then reduced because of an efficiency analysis by these authors, Pendrew and all, that compared the hectares of deforestation linked to the EU consumption for each of these commodities with the average of value of the imports. This impact assessment and this cost benefits analysis of commodities for the scope that other than would trigger some discussion points. The first is the focus on the consumption of imports in detriment of the consumption of internal crops linked to deforestation. Aligned with the first, the second is the omission of data about the consumption of commodities in the scope of the EU. It seems as well that EU only consumes imported crops or only internal crops 100% not embodied by deforestation. The third is that not only all cultures chosen are produced in tropical forests, but also most of them are only produced in these climate domains, including rubber, and are not produced in the European territory as cocoa, coffee, palm oil, or soy, except wood and cattle, produced and consumed in the EU and other climate domains, such as subtropical ones. Very briefly, there's another document that I analyzed, the consultancy report that came to embody much more this impact assessment. And this document is important because there's no, it states that there's no scientific study that assesses all commodities potentially causing deforestation in a comprehensive manner. They highlighted it in this document. And well, going to my conclusions. Okay, thank you. The main topic of my working paper, the quick question, is whether the criteria used to choose the commodities to make part of the scope of the measure are in accordance with the necessity stated in Article 20B. So as it is a work in progress, I think the main conclusions can be that if we continue with this kind of measures, many countries will question these measures. Yesterday, I have a new for you. The Secretary of Trade of Brazil argues that at the Brazilian Congress, the EU's measure takes a punitive rather than cooperative approach to dealing with the challenge of environmental protection. She said they are working to reduce the costs that the measure will impose on Brazilian exporters without prejudice to the possibility of questioning in parallel the legality of the European regulation. So there's another case, and I'm finishing, of Brazil, where there's already under discussion an environmental reciprocity bill. The proposal imposes on countries that sell products to Brazil the same environmental requirements that are imposed on Brazilian exporters. According to the author of this draft law, there will be available in the Brazilian market only goods and products originating from countries that adopt and comply with greenhouse gas emissions levels equal to or lower than those of Brazil. So while the measure is not still applied, let's follow the next actions and reactions provoked by this EU regulation, bearing in mind the necessity of scientific evidence to support this trade environmental related measures. Thank you.
Thank you so much, Vivian, because you pointed out with convincing evidence all the problematic aspects of this piece of EU legislation concerning the green transition and so on and so forth. And the debate that is provoking internationally with all the difficulties in the negotiations for the Mercosur agreement with the European Union. Now I have the pleasure, last but absolutely not least, and Lorand will help me in supporting the mic. I have the pleasure to introduce you Professor Henry Gao, and his paper is about a very sensitive and strategic topic because it deals with China and global trade order post-Ukraine war, and he will explain us the difference of this transition of this shift between from value chain to value chain. Well, Henry Gao is professor of law at the Singapore Management University and senior fellow at the Center for International Governance and Innovation. He has law degrees from 3 continents. He worked as a Chinese representative was the first Chinese lawyer at the WTO Secretariat. He is a consultant, and he has just written a new book in November 2022 on the China state-owned enterprises and the world trading system. With great pleasure, Professor Gao, you have the floor.
Thank you, Chair, for the kind introduction. So I decided that I will be standing here so that it's easier for me to see the slides. So my topic is on China global trade order post-Ukraine war, from value chains to values chains. The second one is not a typo. I deliberately choose the word values. Next, please. So this is an outline of my presentation. As you can see, I'm not going to spend a lot of time on how important China is in global value chains, a factor that everybody knows. Instead, I will be talking about 2 issues, and these are basically mostly political economy issues. The first issue is how China try to use the GVC research, the global value chains research that has arose in recent years to try to reshape the debate on trade policy and also global trade governance. And second, this rise of friendshoring, which I would call alliance of values, how it's going to shape up post-Ukraine war. Next, please. So as we all know, China was not part of the global trading system until about 45 years ago, when China decided to embark on economic reform and started to get into global value chains. Next, please. The main obstacle China has to overcome is the ideological obstacle, which China overcome by Deng Xiaoping, the paramount leader, inventing this new theory of a primary stage of socialism, which basically gives China the license to practice capitalism, even though it calls itself a communist or socialist country. Next, please. And as you can see, this is reflected in China's WTO accession process, where there was a huge debate on whether China is a traditional planned economy or a market economy. At the end result, China said, okay, we are socialist market economy, and that solved the problem and paved the way for China's accession. Next, please. So as you can see, the political issue was the main issue, but China also faced hurdle in trying to get into the global value chains, especially with the complicated rules in trade, especially the rules of origin. And this is reflected most prominently in the textile sector, where you can see, this evolution of different rules, and China tried to work with these different rules. And China was indeed quite successful in that regard, becoming one of the largest exporters of goods in the world and the second largest economy today. Next, please. But even though China has a growing role in global supply chain, next, please. China actually account for relatively less in terms of value added. So that is reflected actually back in 2008, when during the US presidential election, Obama, who was a candidate back then, said, okay, once he become president, he would basically go after China for currency manipulation, which was the reason why China has such huge trade surplus. And in reply, there was this article that probably not many of you read, published in the Wall Street Journal called US-China Trade is Win-Win Game, published by Mr. Zhongshan, who is Mr. Zhongshan, former Vice Minister of Trade of China, okay? So he basically wrote this article and said, okay, look, you know, we export a lot of goods to the US, but the US, you export a lot of services to us. So if you put goods and services together, your trade deficit with China is not as big as you had claimed. But that argument didn't work. So China started to try other ways to persuade the US. Next place. So this is what I'm talking about, where actually around 2008, you see the WTO started to get really interested in this so-called GVC research. When in that year, the chief statistician of the WTO published a paper. In this paper, he said, if you look at the iPod, back then we didn't have an iPhone, we only have the iPod, which was manufactured in China. iPod basically has an export value of $150. So that's the total cost. But that is exported from China. And if you look at the export number, that would be recorded as China's export to the US. But he said that is wrong, because if you look at the value added, only about $4 of a value added in China, and that is less than 3%. And China saw that. Next place. And China decided to use this GVC research as a way to reshift the debate on global trade policy. So at the domestic level, China started to launch the GVC research project with MOCOM and also the State Council of China, both putting a lot of resources, encouraging the researchers to do this type of research. And they were quite successful, not only within China, but also at the international level. When China was able to persuade both the APEC in 2014 and the G20 in 2016 to include the GVC research into the official ministerial statement. And also China started to work with the WTO. In 2011, the WTO launched the so-called Made in the World initiative. And that was basically something that China has helped a lot behind the scenes. Next, please. So why is China so eager to promote GVC research? Well, there was an article by a senior official from China where he mentioned several reasons that China will encourage GVC research. So these include the reasons which are now commonly understood as illustrated by the previous presentations, but also this includes some interesting new perspectives. For example, this could create a new way for carbon measurement. You know, traditionally we are saying that carbon should be based on the country of export or manufacturing. China argued that no, that should not be the case. Instead, the carbon should be based on the country where the value is created. So take the iPod example, $150, only $4 carbon are generated in China, and $146 are generated in the US and the EU and Japan. So they should not be blamed on China. Next, please. But the GVC research also backfired, because as people understand more about the GVC and China's role in the GVC, they also saw how China could use it for its own political purposes. And indeed, this is what happened when, for example, in 2010, China started to impose export restrictions on rare earths against Japan. And this demonstrated the vulnerabilities of relying on China-based supply chains. So in response, the US and other countries started to cut China off from the global value chain. The best example is this so-called yarn forwarding rule in the TPP, whereby the US basically says that, okay, if you are a TPP member like Vietnam that want to export the textiles and clothing products to the US, you have to make sure that the yarn used in the textile must be sourced from within the TPP countries. Traditionally, Vietnam has been sourcing it from China, but after the CPTPP, they are not able to do it anymore because China is not a TPP member. And Trump, when he came into office, was more blunt. He put in this forced decoupling with China, and again, that is also based on the GVC perspective. Next, please. So China's response are fourfold. First of all, there are the Belt and Road Initiative, again, that is well known. And second, there's also the new wave of FTAs. For example, China has been negotiating this RCEP. If you look at the RCEP, many people are seeing that the RCEP is very shallow, but that is actually its beauty, because the RCEP only has a GVC content requirement of 40%. And that is much lower than, for example, 65 to 75% for trucks, for example, and the US and CA. And that makes it easier for the other countries to integrate into the China-centered GVCs. And also China launched the Made in China 2025 initiative, which again is heavily focused on global value chains. And the most recent one is the dual circulation strategy. Why? Many people assume it was a response for the Trump trade war, because that was launched very recently. But I would argue that is also driven by GVC research. Because if you look at one of the major reports from the government-sponsored GVC research, what they were seeing is that the role of exports in China's economic growth has been grossly exaggerated. Instead, we should be focusing on the domestic market. So that explains why now there's this dual circulation strategy. Next, please. So you also see the weaponization of the value chains, for example, with the US adopting the Uyghur Forced Labor Prevention Act, and China also doing all these trade sanctions against other countries, Canada, Australia, and then Lithuania. And the EU responded by adopting the anti-coercion instrument, which I think is a very interesting response against the Chinese aggression based on global value chains. So the biggest impact would come when the Ukraine war was started, because the Ukraine war really shows the risks of relying too much on one country. In this, Russia, for example, for oil and gas supply. So that is why Yellen a year ago started to call for this so-called French sovereign initiative. And therefore, there's this emergence of what I would call the alliance for values. Next, please. So this seems to change value chains, as I mentioned earlier, into value chains. But I would argue that this would probably create more problems than it would resolve. For example, it raises questions on what are the core values. Is climate change part of the core value? If you see yes, then why did the United States, under Trump, withdraw from the Paris Agreement? You can see that even the US was not really committed to these values. And then how broad is the alliance, especially with the addition of India, because India essentially took the same position as China in the Ukraine war by refusing to condemn Russia and continue to buy all these products from Russia. But why is India in the new Indo-Pacific economic framework, but not China? And also, how long will the alliance last? Once the Ukraine war is over, is everybody still going to adopt the same approach towards China? Even though China might invade Taiwan at one point, but Taiwan is not Ukraine, because Taiwan is too far away from everyone. So what are the effects on China? Well, there will be many effects on China, but to conclude, I would say that the biggest impact could be that this would weaken China's confidence in multilateral negotiations and multilateral system, and maybe will lead to China to try to establish competing economic blocs, like the Council for Mutual Economic Assistance, which was established by the Soviet Union during the Cold War. And if that happens, then we would have a further decoupling of the two economic blocs, and instead of just the economic war and Cold War, we might have a real war. And if that happens, next please, we would no longer have either value or values. Thank you so much.
Thank you so much. Apologies for being so strict on the timing. As you have seen, brilliant presentation, so important developments and new developments and the analysis, and so much food for thought. I propose you to pick up 2 questions from the public, and then I ask Daniele whether there are questions from the online people in the meanwhile that you make your 2 questions. So who would like to step in and to intervene? Yes, please. Too late. Can you raise your voice, because otherwise this mic.
Thank you so much for
So sorry.
Yeah.
I need the grazie.
Okay, I hope you can hear me better now. So yeah, my question is specifically for Tibisay and Lorand. So yeah, you said right that the first time type of due diligence is based on self-certification and reputation. But I was wondering about the second one when we are talking about human rights horizontally in the process of production. What is the role of international trade there when we are talking about enforcement? Can we use international trade law to help with enforcement? Because yeah, we have the investment facilitation agreement in the WTO with responsible business conduct provision. We have discussions in FTAs about human rights and yeah, responsible business conduct. But what I see, for example, the Vedanta case, and here in Brazil, when the dump broke, the victims, they are going to the London Commercial Court. So we still have the domestic courts here with, I think, a big role in trying to remedy, right, to offer remedies for the victims. So I don't know if international trade law, the WTO or FTAs, they can help with that, especially when you're talking about human rights, right? I think the individual should be at the center here. So how can we help the victims in these scenarios? Yes, thank you.
Thank you. My name is Natalia Figueiredo. I would like to make a question for Lorand and Tibisay and one for Henry Gao very quickly. My question for Lorand and Tibisay is considering the bias identified by Vivian's work. Now we would like to hear your opinion on the consistency of the EU deforestation regulation, if it would still be justified under the necessity test of GATT 20. And for Professor Henry Gao, my question is, we have been seeing, especially on the part of developing countries such as India and Brazil, a type of non-alignment movement, because we also we do have trade relations with China and US. We are very much dependent on both. So what's your position on how we would, the developing countries would, what are the prospects for developing countries in this new world of two blocks? Thanks a lot.
Just 1 minute. We give the floor to the speakers, and then who would like to start with this mic? You?
Yeah. Okay. So on the first question, I don't much like the idea of trade law being used to enforce obligations. I don't think that's possible. I think what trade law allows you to do is to protect, in the case of human rights, your public morals. And that means that you can interfere with trade to the maximum degree necessary in order to protect public morals. But the idea that you can use trade as a stick to enforce human rights obligations, I think is out. Now, you might end up with the same result in some cases, but the mindset shift is important. Do you want to say anything more about that?
No, I agree with Lorand, and I would say you refer to Vedanta, which I think is an excellent example of how UK tort law is used now to make these companies accountable. And I think that makes much more sense. And I think these frameworks developed at the domestic level, I actually think are much more powerful and are the way to go. Asking trade law to care about human rights, I think, is asking the wrong discipline to do something that is not supposed to do. It might, if you said, lead to the same effect, but I don't think that's right either. Just perhaps on Natalia and deforestation, I was very intrigued by the results you were presenting us. It seems as, while they were developing the regulation, they focus on certain products and on certain type of forest, neglecting actually the fact that deforestation in the meantime in certain areas had decreased. So it looks like lawyers are always very slow and they need to work much more in conjunction with those that actually have the numbers. Because as you say, we might actually not be targeting the right products and the right areas. So I think it was very interesting, your results.
Professor Henry Gao, maybe?
Yeah. That's a very interesting question. I cannot speak on behalf of all developing countries because I understand that each region's the dynamics are very different. So instead, let me just focus on the region that I'm in, Southeast Asia, and also the developing country I'm in, Singapore, even though many people are saying Singapore is not a developing country because it has a per capita GDP of 50,000 US dollars. But anyway, so the Singapore Prime Minister has made clear on many occasions that Singapore does not want to have to choose between the US and China. And I think that reflects the attitude of many countries in the Southeast Asia region, because there's an old saying in China, a distant relative is not as important as a close neighbor. The US, even though is very important, but it's quite far away from Southeast Asia, while China, you know, you like it or not, it is always a close neighbor. You cannot move it away, okay? So that is a fact. So I think the reality is that many countries in the region have to live with China. But there are some interesting new developments because of all this decoupling, you know, and all these, you know, tensions between the US and China. That is, many Chinese firms are actually now investing in the Southeast Asia region, partly because the labor cost in China is rising, the aging population, but also partly because of the decoupling risks. So they want to move to friendly countries so that it would be easier for them to export to the US. So whether or not this strategy would work or not, we don't know, because again, this is a supply chain issue. Even if, let's say, you know, they move part of the operation to Vietnam, a lot of their supplies still come from China. So if you apply, you know, the strict due diligence, you know, then you could still see a lot of these are still based in China. So therefore, you would not benefit from all these tariff concessions and all these like the IPEF deals and so on. But again, I think it's still too early to say, and many countries in the region welcome the Chinese investment, but whether or not this would continue, that is still an open question.
Okay, do we have questions? For sure, another question, and I give the mic to you. Do you have other questions? And also,
it's fine if we don't.
we started 15 minutes later. 15 minutes later. So I will take 5 minutes more.
Thank you. I'll be very quick. So I was pretty interested to know more about the European deforestation regulation. It actually looks like the European Union tropical deforestation regulation, because they don't actually produce any of these things: soy, coffee, wood, cocoa, palm oil, rubber, for that matter. So when you think about some kind of a conservation measure for that matter, it will be fine if you actually have these kind of things at home. But you're trying to really look at the, you know, the kind of conservation happening thousands of miles away. And your argument appears to be that these measures are actually required in order to protect the climate. So these are basically climate mitigation and adaptation measures. So when it comes to even Article 20, I mean, we understand the point that a country basically regulates for its own territory. But if it is actually, you know, if it is a broad regulatory measure, it can even impact in certain countries in an extraterritorial manner. But if the measure is going to only apply to extraterritorial, then how can even a justification under Article 20 apply? And we're also slightly concerned with respect to, you know, some of the Article 20 reincarnation happening in the FTAs. They said that the environment measures, so Article 20B actually relate to environmental measures taken for climate mitigation and adaptation. We know that environment can be brought under multiple provisions of the Article 20. It can be brought under 20B, it can be under 20G for that matter. In India, solar, we even took 20J for that matter. So, you know, it all gives an impression that these are by and large protectionist measures, and they're not really regulating at home, but it has got a huge amount of extraterritorial, pure extraterritorial impact. So I would like to hear your views.
You will change the eating habits. Do you want to have your question?
He actually took my question. I wanted to invite TV and Lorand to, if they can, expose their disagreement on this territorial question and the issue of deforestation.
I think we have to close. All the other question will be for the break. So, Vivian, to you. Do you want to answer to Professor Nedumpar?
Maybe they first.
that's where we disagreed. That's exactly the point. And he said, you sound like a climate denialist. And I'm like, oh my God, don't say it tomorrow. I say it, but I'm not a climate denialist. But I agree that saying that, I mean, when it comes to deforestation per se, there is no question that forest workers' carbon sinks. The IPCC said that in the 90s, the IPCC had faith, and with carbon capture and storage, perhaps fossil fuels could be still used for another 50, 100 years, and that essentially emissions could have been reduced. But there is no question that when you look specifically at deforestation, if you remove these carbon sinks, emissions will just continue to rise. But the point on territoriality, I think, is extremely interesting because, as you say, the EU is saying, well, by reducing deforestation abroad, to some extent, we're also protecting our climate, and our climate is a good, you know. So, and I think that the difficulty there is to show causality, which is what I was saying yesterday to Lorand. I think it's hard. With deforestation, it's easy, but for the, you know, this new due diligence directive, these environmental adverse impacts, to relate that to climate change and tell me that all the products, all the services abroad of, you know, and all these operations of these companies to some extent can affect your climate, I think that's a much harder, you know, test. But for deforestation, I think it's.
Well, the due diligence one doesn't talk about climate, right? So that's a different thing. But on climate, yeah, I think the argument is it's the EU's climate, right? And the fact that the way of protecting your climate involves Brazil's forests is just bad luck for Brazil. I mean, that's, you know, that's the argument, right? So I think you can, well, I don't know about causality because I'm not a climate scientist, but, you know, the argument is that there is causality there. And of course, you don't need much causality in trade law, right? It's pretty basic. And, you know, in the future and blah, blah, blah. The only other thing in terms of 20, I didn't really answer the other question, but you've raised it again, is that's on the territoriality aspect, but then the necessity part is, of course, where everything always falls down. And you know, again, in a nutshell, my view of the chapeau is very simple. Ignore all those silly cases. Is the discrimination, which is product discrimination, in my view, necessary? It's basically what it boils down to. And then what is very interesting is what Vivian was saying about how the products that are selected are all non-EU products. You say the same thing, right? And then you have to wonder whether this is the you know, least discriminatory way that on a product by product basis that the EU could have chosen to achieve its climate change objectives. Now, maybe, you know, Brazil's the only country with this massive rainforest, and it happens that those are where the products are. So maybe it's true if you just focus on all of those products, but also maybe not. You know, that I think depends on the products that the EU has chosen. Having seen the EU's choice of products, regulations, this and that, it's very good at drawing up a matrix and ticking it all off and saying, you know, unless you tick all of these boxes, you can't get these benefits or whatever, and magically those boxes somehow fit the EU's political needs. So they know how to play this game, but you know, you always need to look at their matrix.
The last minute to Vivian, and then we close.
I will be very short. Well, I was talking with Elisa now, and we agreed that this EU Deforestation Act, it's a matter of consumption in the end of the day, and they want to change, the EU want to change the habits of consumption inside the EU through an extraterritorial measure. It's not the point of view here that we have this inside now, but I think it's important.
So we wonder if we have more freedom or less freedom at the end of the day.
Yeah.
Well, join me in thanking very, very much all the speakers for their brilliant papers, and I hope they will develop important contributions in legal journals.
Thank you, Elisa.
Thank you to you. Allora.